can I remove the liens on my property before it is sold? All right, big issue. So let's talk about it. And the answer is a lot of times, it depends. Okay, two types of liens on real property that you guys probably know. There are voluntary liens and there are involuntary liens. Voluntary liens are things that, hey, I agree to have a lien on my property. I'll borrow money and Bank of America is going to put a lien on my property. So if I don't pay it, they can take it. Then there are involuntary liens. Things that you just don't want to be there, but they're there. Such as judgment liens, or property tax liens, or IRS liens, or child support liens, mechanics liens. Those are just liens that you don't like, but they're there anyways. All right. In bankruptcy law, there's something called lien avoidance. All right. And what lien avoidance is that you can use what we call avoiding powers to remove certain liens to the extent they impair exemptions. What does that mean? Okay, we'll talk about that. All right. Now, what an avoiding power is, that's a bankruptcy term, it means that you can file a motion, you can avoid liens, or very simplistically, you can remove a lien. You can remove a lien in bankruptcy. All right, but not every lien. Not all liens are treated the same. Now, you can also remove a lien to the point that it impairs an exemption. What does that mean? All right, what an exemption is that the bankruptcy courts say, you know what, you can keep some of your stuff. We're going to let you keep your stuff. But it either has to be a non-exempt asset, all right? It has to be an exempt asset, or you have to be able to use an exemption to protect it. All right? Let me give you some examples here. When we file bankruptcy, we have something called the wild card exemption. All right? And I use this all the time. And basically, this is what it is. The bankruptcy courts, without going into too much detail, we have about $26,000. The bankruptcy court says, you know what? We're going to give that to you. And you can use that, and you can protect anything that you want to protect that you otherwise would lose. Right. For example, you file bankruptcy. You have what we call a non-exempt asset. You're going to lose it. Money in checking account is probably the easiest one, easiest to get. You have $10,000 in there. All right. Can you file bankruptcy? Well, yeah. The reason why is if you have $26,000 that you can apply to stuff to keep, you can do that. So you have $10,000 in your bank account. Of that $26,000, you apply 10 of it to protect that $10,000. So now that's exempt. You've protected it. Now you have $16,000 left. It's 26 minus 10. And you figure out, okay, how else can I use my wild card exemption to protect other stuff? All right? And that's what we do, is we use exemptions to try to protect assets. You could have $25,000 in your checking account. If you have $26,000, you apply it. The Porsche, good example. The $30,000 Porsche. You can use $26,000 of that Porsche, $26,000 of the exemption, and you can protect it. But you have 30 minus 26, assuming the Porsche is $30,000, it's still what we call exposed by $4,000. So in that situation, we have to talk to the clients, well, your asset's exposed. The bankruptcy court might force the sale. Or he may say, hey, give me $1,000 and we'll settle up. All right, so remember, wild card exemption, you have about $26,000 and you can use on any asset that you otherwise would lose. All right? Now, also assets have what we call built-in exemptions. Remember we talked about the cars a second ago? Cars have an automatic exemption of about $5,100. So automatically, that Porsche could be paid off, and $5,100 of equity is immediately protected, has no relationship to that wild card. Right? Other examples are cash values of life insurance policies. Happens all the time. client has an insurance policy. If they cash it out today, it's worth $30,000. Well, you can lose that in bankruptcy. A bankruptcy court could say, you know what, I want you to sell your insurance policy, which has a cash value of $30,000, and I want you to give it to me so I can give it to your creditors.
How many cars could you have?
You could have, it's all a function of equity. You could have 5 cars that are all leased, doesn't matter. But if you, well, more practical. Let's just say you have 5 cars. One car is paid for, might be worth a couple $1,000s. Another car might have a few $1,000s in equity. But as long as you can take that $26,000 plus that $5,000, the built-in one, but that only applies to one car though. You can't take that $5,000 and spread it out to multiple cars. It's just that one. You can protect all those cars, provided there's enough equity. And the issue comes down to how much is a car worth? All right? We try to push for a low value. If we're having problems with the equity, I'll say to the client, listen, is the car need like any maintenance? Any tires, or is it, did you crash it, or is there a dent? Oh yeah, and so what we'll do is we'll figure out ways in which we can reduce the value legitimately. So I'll say, you know what, the car is, if you go to Kelley Blue Book, the car is worth $10,000. But you know what, it needs a lot of work. And here's a letter from Joe Mechanic saying it needs $3,000 worth of work because of these issues. So we'll bring down from $10,000 down to $7,000. And so that's kind of the process we go through. But as long as you remember, the exemption process is used to protect stuff that you otherwise wouldn't be able to protect. All right, a little bit complicated, but let's talk about some real estate issues. All right. How can I get rid of a secured lien? All right. Can I get rid of a secured lien? I've had clients say, well, I'm filing Chapter 7 and I don't have to pay my mortgage anymore because the loan was wiped out. Well, no, it doesn't work that way. All right. In a Chapter 13 on a personal residence, you can actually wipe out your second trust deed, your third trust deed, all that stuff. But you have to meet certain qualifications. The main thing is this. Your home value is 5. The first trust deed is $525,000, and the second is $100,000. What that means is the second trust deed is completely underwater. In that scenario, you can wipe out a secured debt in Chapter 13. And what you do is you file a motion, and you alter what you're doing. You're saying, Judge, the second's completely underwater, and what the judge does, if he grants the motion, is that secured debt gets transformed into a unsecured debt, and it gets part of that Chapter 13 cookie cutter plan, which we talked about earlier in the day. And provided you make your plan payments, at the end of your Chapter 13, that second goes away. Great thing. And folks did that for a long time a few years ago because it was a great way to wipe out debt. And you might pay back 10% of your debt. If you can pay 10% of your debt, including your second, within a 5-year period, but at the end of the 5 years not have that $150,000 note, it's a great thing. So, yes, sir.
Does it matter what kind of second TD it is? Is it HELOC?
Nope.
Doesn't?
Nope. Second, third, fourth, anything.
So you can wipe out the second, even if you want to keep the property?
Even want to keep the property. Most folks keep the property with the 13. Well, in fact, you keep the property. That's why you do it.
Because you ever tell there's a lot of HELOCs that are coming up due next year. People who took money and they could be in foreclosures.
Might be.
This could be a solution?
Yeah, it could be a solution. But the problem is this, right here, is that what happens if the second trust deed is not completely underwater? For example, in this situation, what you have is the home value of $550, and you have the first trust deed of $525. So the second is not completely underwater. So if the second's not completely underwater, you can't lien strip. You can't do it. And so the issue, the fight in these types of cases is, what is the home worth? We'll say the home was worth X, and maybe the bank will say, no. It's not worth X, it's actually worth more. In fact, it's worth just a little bit more, where the second now is encumbered a little bit. I had a case where we filed a motion to lien strip, and they came back and the home was worth like $10,000 more. All right? But that $10,000 would have encumbered the second, and my clients wouldn't have been able to do a 13, or at least lien strip. And so what the fight was, what's the home worth? We had an appraisal done by an appraiser. They had an attorney who said the appraisal's no good and this is why. What the judge said is, well, we have an appraiser, certified, went through all the various, he's a certified appraiser, versus an attorney who challenged the appraisal with no background, experience, training, etc. So the judge went for us. He took our value because also we showed the evidence that what the home was ultimately worth. So keep that in mind. Now, this is the big deal. And this is probably where something's really important. Can you avoid, get rid of, wipe out a judgment lien through a Chapter 7? Remember, through Chapter 7, you cannot lien strip any secured liens. You can't do it. Chapter 7. All right. Only 13 and 11 as well, but we won't go through those details there. But this is the key thing. If you have a home, you have no equity, can you get rid of a judgment lien? A judgment lien. All right, remember, there's a list of involuntary liens. Can you get rid of a judgment lien? The answer is yes. All right? All right. This is actually a real-life example of a client that we had a couple years ago. Home was worth $1.4 million. The first trustee was $1.3. The second trustee was $300,000. So a total of $1.6, and there was a $200,000 judgment. And the folks who had the judgment were, difficult, maybe? They wanted everything. They said, we're either going to get our money or we're going to have this home go to foreclosure. And that was the option, all right? So we were hired, and we were asked, well, can we get rid of the judgment? I said, yes. All right. So what we did is we filed a motion to avoid a lien. A motion to avoid it, get rid of it, all right? And what we argued, which you can do this, is that we say we have an exemption. And this judgment lien is preventing us from getting this exemption. Let me give you an example and I'll be more specific. So if I have a car, my Porsche, I can use my wild card of $26,000, plus I have that built-in $5,000, my car is totally protected. They cannot touch it, right? Now, in the world of real property, what we said is we have this wild card exemption, and we're entitled to this money, all right? We're entitled to protect stuff. And so this lien on the property, $200,000, we want to take of our wild card, we are applying $1 of our exemption. $1 of our exemption. And we want to be able to make sure that we can keep our $1 with exemption. And the property is, or actually the judgment is preventing us from doing that. And so we file the motion, and what the court's going to say is, yeah, since you have exemptions that you can actually use and apply, we can actually get rid of a judgment on property. So what we're able to do is file the motion, and the court granted it. And so what happened was that $200,000 went away, and they were able to short sale the property. The client was actually in bankruptcy, and it worked out really well. So the bottom line is, if you have an existing judgment on real property, and that judgment creditor is being kind of challenging, you can actually hire an attorney and get rid of that judgment in a Chapter 7. There's some hurdles you got to get through, and there's some steps, but at the end of the day, as long as you keep in mind judgment, you can get rid of it. What's that?
What's the point in putting a lien on a house?
Well, two reasons. One, the owner has to file bankruptcy. They may not file. And secondly, if you get a judgment and you put a lien on the property, then eventually that homeowner has to deal with it in some way. If there's equity in the home, remember, first is paid, second is paid, judgment's paid. All that stuff is paid before the homeowner gets a penny. So it's always good, if you have a judgment, it's always good to put liens on properties because it's going to increase the likelihood of being paid.
Can we put a second on after the lien is on?
Can they put a second on the property? Yeah, most banks, though, will not lend behind a judgment creditor. What is judgment? They'll have to, what they call subordinate. That may happen. So, yeah. Yes, ma'am.
I'm in London many times, so a client will think that, well, I filed bankruptcy, so that judgment went away. Well, actually, didn't realize, well, my attorney took care of that. Well, didn't realize that the attorney didn't actually vacate the lien. So they don't have to pay it, but when the house sells, they
All right. No, it's actually, yeah, see, Jim and I had this issue, and it's, I'll talk about it in a second, but I'll bring it up now. All right. When you file bankruptcy, the debts you owe go away. But if there are liens on properties, they don't go away. All right? What do you mean? Well, okay. So, Len's not here anymore. Len gets a judgment against him for $20,000. Yeah. I'll hit Jim. Jim has a judgment against him for $20,000. All right? And that plaintiff files a lien on his home, which means that if Jim wants to sell the home, he's going to have to pay that judgment. Jim files bankruptcy. So Jim personally has no legal obligation to pay that debt. But Jim is not the home. Jim and the home are separate. What that means is that lien still exists on the property, even though there's no obligation to pay it. And our client, who I handled bankruptcy for, and Jim was the agent, the challenge was explaining to her that, yeah, you filed bankruptcy and you have no obligation to pay the debt, but you're not the home. That lien is still on your property and it still has to be addressed. So, well, I understand because I don't have to pay it. Yeah, but it's still on the property. Remember, bankruptcy only impacts you as a person, not the stuff you might own. And so in that situation, what unfortunately had to happen is that when she sold her home, she paid the first, and she paid the second, and she paid the HOA secured note, and she paid the 2 judgments.
There were at least 2 judgments.
Yeah, so the 2 judgments, and then they got X. Now, she got a lot of money in equity, and at the end of the day, she just didn't, because she had to pay the judgments, and ultimately had to be paid. Yeah.
Can the bankruptcy attorney then, like you did, vacate the judgment when
Yeah.
you filed the vacate?
Yeah, at the time you are in bankruptcy, it's the time to get rid of the judgment liens.
Right.
The practical problem, though, is that clients have to pay for that above and beyond. So if I have a client, what I'll tell them is, listen, this is going to be an issue, and if you want us to handle it, we can do it, but it's not part of the flat fee, and some folks do, some folks don't. It just depends. But the key thing you got to remember is just because you file bankruptcy doesn't mean your judgment liens are going to go away. They're still going to be there, and they're going to get you.
Doesn't a judgment automatically go to property?
No.
It does not.
No.
They have to file a
You have to record an abstracted judgment in the county where the real property is located. Yeah. So if you own property in LA, and I got a judgment against you in Orange County, well, I shouldn't say that. If you own property in LA, and I went to the Orange County Superior Court and we won, and I recorded in Orange County, that's great. But it's not going to impact LA. Yeah, it's a good question. Yes, ma'am.
How long does it take if you have a don't file bankruptcy and just have creditors unsecured debt that's in the cloud? And how long is it before they have to get rid of it? That's a credit question, I guess. But before they have to get rid of it from your credit.
On your credit report?
Yes.
Yeah. I have a separate question that deals with credit report issues in the context of bankruptcy, which I think will answer your question. Okay.
So that property was short sale after?
It did. It did. And, and the thing was, the agents were very motivated to get rid of the judgment because, they're representing some clients on a pretty pricey property. And so their desire and willingness to pay for our time to do it was kind of a no-brainer because their commissions were, very high. So, but it was a good deal. And ultimately, the irony behind it all is that these folks who were being pretty difficult and not working with us, they had nothing. And they're offered like $10,000 or $15,000 or something like that, some reasonable amount. And they got Zippo because they didn't really understand some of these nuances. So sort of keep in mind as you're working with clients.